Congressman pulled a fire alarm right before a really important vote and has now been formally censured by the House.
First of all, Congress is going ham lately. So many unprecedented things have happened this year. The Speaker of the House was removed for the first time in history. George Liar Liar Pants of Fire Santos was expelled from the House, which had only happened 2 other times since the Civil War. And multiple other censures have already taken place.
But returning to this fire alarm incident, Representative Bowman, a Democrat, did pull the alarm, causing the entire building to evacuate. And Republicans allege that he did this on purpose to obstruct a vote. But Bowman maintains that it was an innocent mistake. Specifically that he was actually trying to rush to get to that vote and thought pulling the fire alarm would open the door.
Here's the actual video again. For context, these are the signs you see him taking down before pulling the alarm. You can decide for yourself what you think happened.
Although Bowman maintains that it was an accident, he did actually plead guilty to a misdemeanor charge for pulling the alarm.
So what does the censure actually do, though?
Basically nothing. It's essentially just a formal finger wag from Congress, publicly shaming you for something you did.
But you still keep your role as a representative and there's no real consequence.
Threw her burrito bowl at a Chipotle worker and was charged with 1 count of assault.
Yes, throwing something in a person's face is assault.
At court, the woman tried to defend her actions by telling the judge that her burrito bowl looked disgusting, to which the judge responded, "I bet you aren't going to be happy about the food you get in jail."
The woman ultimately pleaded guilty and the judge sentenced her to 180 days in jail. But then the judge got creative. He offered her only 30 days in jail if she was willing to spend the remainder of her 180-day sentence working at a fast food restaurant, and the woman agreed.
So this is a creative idea, but is it actually legal for the judge to do this? Generally, yes. In most situations, judges have super broad discretion to determine what punishments someone actually faces.
Typically this comes in the form of prison time or fines, but judges can step outside of the box if they want. One judge in Ohio is particularly renowned for his creative sentences, including sentencing someone convicted of criminal mischief at a county fair to shovel animal poop from that fair, and sentencing someone convicted of vandalism to paint the courthouse with a toothbrush.
Importantly, these creative sentences are usually presented as a choice, as in you can go to jail or you can do this other thing. This helps avoid the argument that these are cruel and unusual punishments, which would be a violation of the 8th Amendment.
Overall, some people really like these creative sentences, finding them more meaningful and a good way to reduce overcrowded jails.
But others prefer the judges stick to traditional punishments instead of experiments. For example, some might ask, who's actually going to hire this woman?
And isn't it kind of a total diss to actual fast food workers to use their real everyday job as an alternative to jail? A 10-year-old boy in Mississippi was arrested for peeing in a parking lot.
Seriously? Our last video was about farts.
This one's actually important. Anyway, reports say that the boy was waiting for his mom in the car in a parking lot and had to use the bathroom. But he couldn't find one, so he chose to just go outside beside the car.
A passing police officer happened to see this and approached him. This first officer went to go find the mom and just warned both of them that he couldn't be peeing in public.
Fair enough.
But then other officers showed up and one of them insisted on arresting the boy. And so he was put in the back of a police car and brought to the police station to be booked, which included being placed in a jail cell. The boy then entered a plea bargain with prosecutors and the judge gave him 3 months probation. And also signed him a 2-page book report on Kobe Bryant for some odd reason.
So, yes, urinating in public is illegal, but police always have the discretion to not enforce the myriad laws we all break every day, and many believe these officers should have used that discretion here.
In fact, the arresting officer has actually been fired for violating the department's policies on dealing with juveniles, and the boy's mother argues that his race played a role in choosing to arrest.
But it's very important to understand that it wasn't just the police choosing to arrest a 10-year-old boy. Prosecutors also chose to actually file these charges and proceed with them, and the judge also chose to hand down a sentence.
It's important to understand that in the criminal system, there are 3 levels of power, and all 3 of them have the power to say, meh, this case is pretty dumb and I'm not dealing with it.
And many think it was dumb to actually arrest, charge, and sentence this boy, considering that Mississippi has much more serious crime it could be focusing on. Like, for example, the highest murder rate in the nation. Has been declared ineligible to run for president. At least that's what headlines like these are saying. But that's actually pretty misleading.
And why did you lead with that? Anyway, here's what actually happened. Back in September, this lawsuit was filed with the Colorado State Court. The point was to have Trump deemed ineligible to have his name on the Colorado ballot in the 2024 election because, according to the lawsuit, he violated Section 3 of the 14th Amendment, also known as the Disqualification Clause.
Which, put very simply, says you can't run for president or any other office if you've engaged in an insurrection. The lawsuit spends over 100 pages making the case that Trump did commit an insurrection, including numerous tweets, news articles, and photos. The lawsuit made its way up to the Colorado Supreme Court, who agreed. They held that Trump is constitutionally ineligible to run, and so he cannot appear on the Colorado ballot.
Okay, tons of things. First, this ruling only applies to the Colorado ballot and the 10 electoral votes to be won there, although other state courts could theoretically do this.
Second, this is completely unprecedented. A former president has never been removed from a presidential ballot. There are a lot of critics of this ruling, and the term civil war is now trending on X.
Critics say that Trump has never been convicted of an insurrection insurrection, nor was he ever impeached for it. And that the court, which is comprised of all Democrat justices, is politically weaponizing the law. Whereas supporters of the decision say that the disqualification clause doesn't actually require any convictions or impeachment, just a determination that an insurrection was committed, which the court found based on the evidence.
The last thing to note here, and perhaps the most important, is that this ruling from Colorado is absolutely going to be appealed up to the U.S. Supreme Court. They'll have the final say, and it's very likely they'll overturn this ruling and void the whole thing.
Just like Colorado, the state of Maine has also just announced that Trump will not be included on their presidential ballot because, according to them, he engaged in an insurrection on January 6th. And under Section 3 of the 14th Amendment, he is now disqualified from being president.
But what Maine and Colorado have done here doesn't actually mean anything yet, because this issue will ultimately be decided by the Supreme Court. And their decision here, whether or not states can ban Trump from appearing on their ballots, will be one of the biggest rulings ever.
I feel like that's happening a lot lately. Anyway, these are some of the main arguments that the Supreme Court will consider. First, Trump has never been criminally convicted of insurrection, and so his supporters argue that he's entitled to his due process rights before being banned from the presidency.
But on the other hand, Section 3 doesn't explicitly require any criminal conviction, just a finding that an insurrection occurred, which both Colorado and Maine have determined for themselves. The Colorado case in particular laid out more than 100 pages of evidence and testimony to support the claim that Trump incited an insurrection.
Second, some legal scholars believe that Section 3 doesn't actually apply to the president, and they also believe that the 14th Amendment, read as a whole, says that only Congress and not states can disqualify the president.
Both of these are huge controversies, the details of which will bore you. And all this said, the law isn't immune from politics. If you believe that it is, I have a beach house in Idaho to sell you.
Got a beach house I can sell you in Idaho.
And the Supreme Court currently skews conservative, with 3 of the 9 justices actually appointed by Trump himself.
Employees at a sporting goods store were fired for a reason that might surprise you.
So these employees were selling a pistol to a customer, or so they thought. The customer actually snatched the firearm and ran out of the store.
Because stealing guns is, bad, 3 employees chased the thief all the way to the parking lot. But they lost sight of him and he got away.
A few days later, upper management fired these 3 employees. Not because they were too slow, but rather because they decided to chase the thief at all. The store's internal policy on loss prevention states that employees are not allowed to chase or physically subdue any shoplifters. And that's actually a really common policy.
Companies have pretty universally decided that they rather just accept the cost of lost merchandise than risk lawsuits from employees trying to stop shoplifters. Because the employees could get hurt, leading to workers' comp claims, or even the shoplifter could get hurt. And as ridiculous as it might sound, shoplifters have been known to sue for getting hurt while stealing.
Whether or not you agree with it, that's the logic here. What's interesting though is that these job policies are actually different from the law. Although companies don't want employees stopping shoplifters, most states do give employees the legal right to do so. This is called the shopkeeper's privilege, which generally applies as long as these criteria are met.
This is a good example that your job's policies are not the law. And employers can fire your ass for doing something even if it's technically legal. Like calling your boss a big fat stinky poo-poo face.